Good morning.
Morning, Chair.
Yes, Mr. Siminya.
Morning, Chair and Commissioners. We have sat down today to have the cross-examination of Mr. Ackerman, which will happen virtually.
Yes. Thank you.
Commissioner.
Ms. Ranto.
Thank you, Commissioners, and good morning. Commissioners, before we start, we were just advised by the Secretariat that the bundles that we're going to be dealing with are found in your bundles. There's a yellow binder. Behind the yellow binder is an application for cross-examination by SAPS, and then just after that one, it's SAPS index cross-examination of Ackerman. Is the first one, and then followed by another bundle that we titled SAPS Bundle 1, General Jacobs affidavits.
Yes.
And the rest will be based on the Galata bundle.
Awesome.
Thank you, Chair. Good morning, Mr. Ackerman.
Good morning.
Firstly, to avoid wasting a lot of the Commissioner's time, we would like to start with the issue of the period of political interference on the part of the SAPS. I'm sure you are aware that what you are going to be questioned on is on the basis of your evidence against the SAPS. So I represent the SAPS. You are aware of that?
That's correct.
Thank you, Advocate Ackerman. Perhaps if you may just clarify the issue of political interference by the SAPS in particular. When did it start exactly, in your view? Or what event or incident?
Well, a non-investigation of the TRC cases and all the meetings I had with Commissioner De Beer, when he informed me that he unfortunately cannot investigate the TRC matters after discussions with the commissioner, the national commissioner. I had many meetings with him in connection with matters, and it was only that he investigated, but it's only in relation to the TRC cases that he said he could not assist me.
So the political interference started when Commissioner De Beer said that he could not assist you?
That's correct.
Okay. If I may refer you to Commissioner De Beer's letter. It's bundle 1. My apologies, that is included in bundle 1. Anyway, it's fine. Let's proceed, Mr. Ackerman. We can get the next. Okay, you say it started during General De Beer's interaction with you.
That's correct.
Yes. The allegations before the Commission are that, pursuant to your discussions with General or Commissioner De Beer, there was a request by Commissioner De Beer stating that the National Commissioner had indicated that the NDPP should be approached so that he could ask the President to make pronouncement, in other words, to change the proclamation to make it in such a way that the SAPS would be the one responsible for that. You remember the correspondence between you and Commissioner?
I know the correspondence. I'm not aware of that it happened.
Okay. Yes. That, to be specific, is a Galata bundle is page 296 of, I think it's bundle 1, but it's the Commissioner's bundle. The letter is found on page 296 to 297 for the convenience of the Commissioners. In that letter, your evidence before the Commission is that you expected the then NDPP advocate Bulelani Ngcuka to approach the president as suggested by Commissioner De Beer, isn't it?
Well, Mr. Nuka was in possession of that letter,
Yes.
and he gave evidence to the effect that he did not approach the president.
Yes, the question is, your view was that he ought to have approached the president, isn't it?
No, why?
In terms of what is alleged as political or part of political interference in the, your very own affidavit. That's paragraph, what, the 2015 affidavit, political interference. Apologies, Commissioners. Statement. 2015. What you indicated as part of political interference was Mr. Bulelani Ngcuka's refusal to approach the president so that clarity could be sought. You remember that?
Yeah, but that's not political interference. I asked the police to assist me in the investigation. And in terms of the Police Act, it's their duty to investigate crime like murder and torture. It's in the Act. Now, why do I need the president?
So Mr. Ngcuka's failure to approach the president did not constitute political interference, in your view?
No. I asked the police.
Okay. And then the issue of the letter sent to, by General Jacobs on the 6th of December 2006, as alleged in your affidavit, you remember that? More specifically, if I may refer you to the 2015 affidavit that you deposed to in support of the Nkadimeng application. It's paragraph 331 of that affidavit, the 2015 affidavit.
I'll have a look, but in a subsequent affidavit, I referred to that document. Have you seen that?
Go to paragraph 331.
This might be-
Maybe just to assist you, Mr. Ackerman,
Yeah.
in your 2015 affidavit, that is on page 14 of the Galata bundle,
Yeah.
paragraph 30, you deal with political interference. You see that?
Yes.
And you start by saying the first act of political interference which effectively stopped the work of the PCLU was the suspension of such cases during 2004. You see that one?
Paragraph, what is that?
32 of your
Okay.
2015 affidavit.
Yes, I see that.
And you said it was as a result of the suspension of such cases during 2004, pending the issuing of new prosecution guidelines. You saw that one? Or you
Yes,
said-
but you asked me first, what do I regard as the first, and I said that it is the non-investigation of cases. That occurred in end of 2003, in September 2003.
Okay,
You have, they stated that they're not going to investigate. The National Commissioner decided. That is political interference too. I might have missed that one.
but that's what I'm trying to follow from the chronology that you gave, that you started off with the first act. You are very specific that the first act was the moratorium or suspension of investigations. And that's why I wanted to understand so that we all on the same page as to when did it exactly start.
Okay, make that the second interference.
I beg your pardon?
The one you're reading in paragraph 32, let's make that the second political interference.
We can't.
We can.
How do you do that, Mr. Ackerman? Your testimony in terms of what you put under oath, in terms of your statement, you made it clear that it was 2004. Today you are changing your version to be now the first act of political intervention, interference to have occurred during your interaction with, I don't know who, but it had to do with investigation. So what do we make of that?
Exactly what I said.
Okay. So you are changing
You
the first
remind,
act.
yeah, you reminded me of another interference.
Ms. Ranto, maybe the chair and Commissioner Gabriel are following. I don't.
Okay.
You see, if you're going to compare the two, you refer us to the first and then to the second, so that also in fairness to the witness, so that if he wants to go to the place that you're pointing out, he should do so, if need be. So I'm a bit lost. Can you just remind us and maybe refer us, if possible, what the witness would have said in the first place and what he would have said in the second place?
Okay, my apologies for that confusion, commissioners. Specifically, what I'm trying to find out from Mr. Ackerman is exactly as to when, in his version, the police started interfering politically with the investigation of TRC cases.
Yes, I follow that.
Yes,
That is the De Beer issue, is it?
No. I was following. The reason why I asked, I'm referring him to his affidavit that was filed in the Nkadime matter.
Thank you.
Because
let's go to his affidavit.
Yes,
What
commissioners.
paragraph?
No, apologies. If I may refer the commissioners, that is found in Ackerman's bundle 3, the statement of the affidavit that was filed by Mr. Ackerman in support of the 2015 Nkadime matter. In paragraph 30, my apology, 32, there's a heading or a title, political interference.
Yes.
And then Mr. Ackerman gives an account of what was the first act and second and so on. So specifically paragraph 32, I just referred to him where in his own affidavit, the first act occurred when there was a moratorium or suspension of the investigation of TRC cases. What we are trying to establish from Mr. Ackerman is that we are all lumped into this political interference pot, and we're trying to understand, insofar as the police service is concerned, where do we start drawing the line, or where did it all begin? So.
Yes, you don't have to explain further. You can carry on.
Thank you very much,
Thank
Commissioners.
you.
My apologies for an inconvenience. Mr. Ackerman, you did indicate that I just, yeah. So now this morning, you indicated that my question actually reminded you that the first act was not the one that you stated in paragraph 32. Is that not so?
Yes, that's correct. You referred me to another interference.
And that became another one that you just came up with this morning when I asked you that question. That's the first one.
No, you referred me to that one. It's obvious the documents are before the court. I don't know what if you call it political interference or interference, it doesn't matter. You referred me to that one and I said it's interference. They're not investigating the matters.
The reason
It's
why...
all on the
Oh, sorry, Mr. Ackerman, proceed.
I say, well, there are documents to that effect. Everybody can read it. It's
Yeah,
dated 26th of September 2003. They wrote to me and said they're not going to investigate.
Okay. And then let's now move to the next act of political interference that you're dealing with, and that is found in paragraph 33.1, where you refer to a letter by General Jacobs. That is also in your paragraph, Ackerman's bundle 3. It's page 15, paginated page 15, paragraph 33.1.
Yes?
You recall talking about the letter that General Jacobs sent on the 6th of December 2006 to the PCLU.
Yeah, that's correct.
And subsequent to that, you deposed to another affidavit in 2025, that was in October, specifically paragraph 6.1.
Can you read it to me, please?
Your October 2025 affidavit, there is paragraph 6.1.
Yes, I have it.
You giving an explanation. So it reads thus: in respect of paragraph 33.1 of my aforesaid affidavit and paragraph 234 of the Galata affidavit, I point out that the letter from the SAPS legal support Major General Jacobs was probably addressed to the NDPP, not the Priority Crimes Litigation Unit. You saw that paragraph.
That's correct.
Now, the question is, what led you to change that version from a definite position that you put in terms of your 2015 affidavit to a probability in your affidavit as contained in the October 2025 affidavit?
I'll tell you why. I was asked in last year, must be October or wherever it was, to confirm the Kalata affidavit. It's 1,000 pages, all the documents. I read through it, and then I come on this letter that was sent to, I didn't see the letter. When I drafted my affidavit, it came up that such a letter was received by the PCLU, and I accepted it under PCLU, and I therefore received it. But then when I read through the documents in October, not the documents of Chris McAdam in, when was that, November last year, it's for the first time that I read about secret task teams, ministers' forums, ministerial committees. Then I realized I didn't know anything about that. And that's when I changed my, it says, it must have been received by the PCLU, and I did not read it. And that's why I changed it. But if I recall correctly, Commissioner Jacobs stated in one of his affidavits that that letter was not sent to me, it was an email to Mtunzi Maga. And that email is in the document. It was not referred to the PCLU. I think it was to Mtunzi Maga. Is it not? That's my recollection.
Okay. Would I be correct that at the time when you deposed to the 2015 affidavit, You did not have a sight of the letter that you referred to in that affidavit.
No, I was informed that there was such a letter.
You were informed that there was such a letter, and then you gave testimony
I was
that
in-
it existed.
I was in the impression existed. I was shown a number of, it was a last, at least 30, 50 pages of documents that I've submitted to different people. And when it was given stated that there was such a letter, I said yes. I was under impression, yes. I did receive such a letter. I have no independent memory of such a letter. And for that matter, there are number of documents that I've given evidence to that I wrote that I can't even recall. I have no independent memory of all those letters.
So what you stated in paragraph 33.1 of that affidavit is untrue, because you did not see
No,
that letter.
no, it's not untrue.
But you said, you stated that without any evidence, because you did not see the letter.
You know, maybe I've stated that in 2015. That's correct. I've no independent memory of such a letter, but it was put to me that it was sent to the PCLU. There were quite a few letters that were shown that I've written and I received that I had no independent memory of. And this was one of them. But what triggered me was when there was mention about, I don't know if it in that letter about the Directors General's Committee. I did not know anything about the Director General's Committee. I only, for the first time, heard about that it registered was when I read the documents submitted by Chris McAdam that he found in a safe, secret documents.
Now, with the benefit of what General Jacobs said about the non-existence of the letter, because in his affidavit, which you just referred to, he explained that it was actually communication, that an email communication between him and Advocate Mhaga. What have you got to say when you then take into consideration what you said in paragraph 33.1?
No, what happened was he then read my affidavit and saw that I stated that I haven't received the letter, and then he made an affidavit saying it was not a letter, it was an email that he sent to Mana.
Who gave you the information about the letter being sent to the PCLU in the first place? You said you were informed. Who did? Who informed you?
It was the Mr. Barney. He had the documents with him.
Oh, so this statement, Mr. Vani, when you say Mr.
Yes.
Vani, you're referring to Mr. Vani, your counsel.
That's correct.
So when you deposed to the affidavit, you did not see a letter, you relied on what Mr. Vani told you about
Yes.
the letter from General Jacobs. Okay.
Yes.
But you can accept today that no such letter is in existence, isn't it, Mr. Arman?
No, there's an email in existence.
Yes, it's an email communication.
And that's probably what Mr. Barney also saw.
We'll deal with that, the contents of the email exercise. Perhaps if we may then go to the issue of lack of investigators, that you said SAPS refused to give or to assign investigators to assist in the TRC cases. Remember your complaint?
Yes, that's correct. Not a complaint, it was just I wrote to them and asked for their assistance to investigate.
Okay. The formation of the ITT, Interdepartmental Task Team. Am I correct that you were part of that?
That's correct.
Am I also correct that you presented an audit report before the task team?
That's correct.
And that also included a task that was given to General Jacobs to also do some audit coming from the police side, isn't it?
Yes, that's correct. He had to give all the documents, all the cases that must be investigated by the police, like I did.
Okay.
All outstanding investigations. That was the question at the ITT. I just call it the task team. There's so many task teams, but that's a task team, the legitimate one.
And you served in the same task team with General Jacobs, isn't it?
That is correct.
And during his testimony, General Jacobs, before the commission, he explained that you have, or you had cordial relationship, you have worked in other matters before that. Is that correct?
That's correct. That's correct.
So,
Had lots of dealings with him beforehand. And as you can look at my the mandate of the matters that I was mandated to prosecute, and there are, I think, at least 10 categories, and
Yes,
they investigate.
Mr. Ackerman, if you have agreed, you don't have to explain further. Keep it as short as you possibly can, please.
I'll do my best.
yeah, just based on your interaction with General Jacobs, did you have any reason to believe that he had an intention to interfere politically with the investigation of, or investigations of the TRC cases?
That's a difficult question. If you can discuss it later, the documents. I tell you, if you ask my opinion. Well, I'm of the view that he was not the person who forged the documents, that he did not form part of this enterprise to stop TRC prosecutions. But at some stage, he became aware of the fact that their documents were forged and something was off. But he just did, perhaps, you asked me to speculate. The commissioner told him what to do, and he did that. But he knew that that document was forged.
Before we get to the document, we'll get to the document. I just wanted to understand, because his letter of the 6th, by now we know it was an email, of the 6th of December 2006. You pointed out that it was also part of what you fingered as political interference. And that is why I wanted to understand from your interaction with General Jacobs, what's the basis for you to have concluded that General Jacobs would have politically interfered with the TRC cases?
Well, how did he interfere? I'm not clear. What do you state? How did he interfere? I stated that he sent me a MAGA email in connection with the directors general must give their views on the matter. Is that what you're referring to?
Yeah, I wanted to know, is he a person that, in your view, would have a reason to interfere or to sabotage the investigation of the TRC cases? And that I was asking based on your interaction with him.
He has got no motive to do it. But he did interfere because of probably orders he received from the National Commissioner. So you ask me whether he did interfere? Yes, he did.
Thank you, Mr. Ackerman. Let's go to the next one where you deal with what you term direct acts of political interference. And then I may refer you to paragraph 32 of your affidavit. That's bundle 3, Ackerman's bundle 3. Paragraph 32, page 14, paginated page 14.
So many documents here. Mr. Fenter will give me the document. Yes, I've got political interference, page 14. Which paragraph are you referring?
Just to the similar one. Sorry. Paragraph 32. It's just a minute. Okay. That was the stop, yeah. We now deal with the same paragraph 32 that we dealt with. Sorry about that, Mr. Ackerman. We're going back to that.
Okay, I'm
That's
with
why I
it.
said, yeah, where you dealt with the first act of political interference about the suspension of investigation that occurred in 2004. Remember that?
Yes.
And your evidence
This
is
is
that.
the new.
Yeah, your evidence is that that was because of the moratorium pending amendment to the prosecution policy, isn't it?
Yes, that was the 11th of November. When was that? Was the day that I wanted to arrest the 3 perpetrators in the Chikani matter.
We'll get to the Chikani matter. I want to understand. There was a moratorium that was placed,
Yes.
yes, pending the prosecution or the amendment to the prosecution policy, isn't it?
Yes.
Yes. And I want us just to get a common understanding that obviously SAPS had nothing to do with that process, isn't it? Can we agree?
Well, no. Police said no, they were not involved.
Thank you. Then we can
They were
proceed.
in any event not investigating at that stage.
Yes. So they were not investigating at that stage.
Yeah, so it didn't affect them. They're not investigating.
Let's go to the Chikani matter. You deal with the Chikani matter in paragraph 30. Actually, from 30, 29. Paragraph 29 of your 2015 affidavit.
Yeah,
That's
what page is it?
Page 13, bundle 3. That's Ackerman bundle 3.
Yes, I'm here. Paragraph 29.
29, yes, that's when the Chikani matter has been dealt with. Yeah.
I must apologize. I didn't have much ink in this printer, so it's very unclear here.
But I think you have said a lot in terms of the
Yeah.
Chikani matter. I'm not going to get
Yeah.
into the details of that, but
Okay.
specifically, yes, specifically in the Chikani matter, your evidence before the commission is that the Chikani matter was a direct act of political interference. You remember your testimony to say that, in fact, that's what led to the collapse of the ITT. Is that not so? The decision on whether or not to prosecute Reverend Chikani.
But I did decide to prosecute Reverend Chikani, the perpetrators.
Yes.
And the minister stopped me.
The minister stopped you.
Not me.
When was the decision taken to prosecute Chikani?
Well, I took that decision after prosecution of Dr. Walter Basson, and the matter was investigated. I had most of the evidence, and it must be 2003 that I took the decision and I drafted the indictments. So if you ask me when, I'd say 2003 I decided.
And when did the minister interfere?
In specific date will be in 2004. When I'm not sure. I think it's November 2004. Is it not so?
The decision, yes. Your
Not the
evidence
decision.
that decision, yes, November 2004. My question
The day
is,
they appeared, that day they appeared in court.
what I'm
Supposed
trying
to
to,
appear.
yes, what I'm trying to find out from you are two things, Mr. Ackerman. First, I wanted to find out, when did you take decision to prosecute?
2003.
2003. When did the minister interfere?
End of 2004.
And which minister was that?
I'm not sure about that date. I'm just thinking because when was the date that they were supposed to appear in court? Do you have that date?
Okay.
Can I inquire from my...
In the meantime, you may respond to who was the minister.
was Mr. Minister Mbandla.
Minister Mabandla. And then the decision to prosecute in your statement. Well, we can look for it, but I know that you mentioned November. It was November 2004 on your version. You remember that?
To do what? Not to. I didn't take the decision then.
The decision to prosecute.
They informed that.
Sorry, Mr. Ackerman, when did you take decision to prosecute Mr. Chikani?
2003.
When in 2003?
During 2003.
During 2003. And the minister interfered end of 2004.
Yeah. If that is the date they appeared in, was supposed to appear in court when she stopped the prosecution and the appearance of the accused in court.
Okay. Now I'd like to refer you to the report that you prepared for Dr. Ramaite. That's the audit report. It's dated 24th of October, 2006. And that's the report that you presented to the ITT meeting of the 25th of October, 2006. Now that report, commissioners, is found, the ITT minutes, 25th. Yeah, it's page, the report is the ITT minutes of the 24th. The report is found in bundle, what we termed cross-examination of Ackerman. The bundle, that would be pages 2 to 30 of that bundle, commissioners. It's page 2, sorry, page 2 to page 8, yes.
Well, it's a document. I haven't got it in front of me. We'll have to look for it. Can you refer it, just get number in the bundle or?
SAPS bundle, bundle for cross-examination of Ackerman. Can someone assist Mr. Ackerman with the bundle? Page 2 of that bundle.
I can't find it here. You must give them the page number or the.
It's page 2 of that bundle. The bundle that we say, it's SAPS index.
I have it now. It's page 2. Yes, I have it.
Yes. You confirm that was the report that you prepared for Dr. Ramaite, isn't it, Mr.?
No, it's for the task team.
It's addressed to Dr. Ramaite,
Yes, he was the chairman of the task team.
and you compiled this report? Or the
In
auditing-
fact, I didn't compile this report.
You presented
I
it
think
to
Mr.
the
Maga
ITT.
compiled this report.
Okay. It was Mr. Mahaga who compiled, but you presented it to the ITT.
That's correct.
And then I'd like to refer you to paragraph 4.1.5 of that report. It's on page 8. Page 8 of
Page
that.
8? Yeah. Yeah, I've got it. Paragraph 4.
4.1.5.
4.1.5. Yes.
And then it reads like beginning of October 2006, it was decided to put prosecution on hold pending obtaining of a legal opinion on whether the accused have received indemnity or not in terms of the Indemnity Act. Do you see that paragraph?
Yes. I know the facts refer to that.
And yeah, if maybe you can just go to 4.1 there. Do you see 4.1?
Yes.
Yes, what is stated there, you agree that was in relation to the case of State versus Otto and others.
Yes, it says indictment already drafted in 2004. Prosecution was put on hold pending approval of guidelines.
Yes. So when it was, when you indicated in the report that indictment was drafted in 2004, what would that mean, or what did that mean in relation to
You mean
this?
this means to prosecute them.
It means the decision to prosecute.
Yeah.
So when was the decision taken exactly? If the
It says
was
indictment already drafted in 2004.
okay, and then it further read, it says prosecution was put on hold pending approval of guidelines.
Guidelines, that's correct.
Yes. So, meaning the prosecution in the State versus Otto and others was pended whilst there was a legal opinion that was being obtained. Is that not so, according to what is written there?
Yeah, but back to this opinion that was written. Is that what you wanted to know about this opinion?
No, we are going to what you said created a problem insofar as the Chikani decision was concerned. So we are trying to establish as to exactly when the Chikani matter became a problem or when the actual interference occurred in the Chikani matter.
The actual interference in the Chikani matter was when they were supposed to appear in court, I think November in 2004.
Okay. The delay in making sure that they appear in court, what was the cause for the delay?
Was the minister stopping the prosecution?
How?
She picked up the evidence. I've already given it, but I got a call from the day of the appearance of the three accused that I must put, the minister says I must stop the prosecution now. They must not appear in court because of the drafting of guidelines. I said to him, I don't take any instructions from the minister. Only the NDPP can give me instructions.
And when was that, Mr. Ackerman?
That must be 11 November 2004, if that was the date I appeared in court, supposed to appear in court.
I'm going to take you back to what is contained in the report that you presented before the ITT.
Yes?
4.1.1 of the same report, it is indicated that indictment already drafted in 2004, prosecution was put on hold pending approval of guidelines, not pending minister's approval or any other reason.
No,
The
I said the
prosecution was put on
minister.
hold. It says the prosecution was put on hold pending approval of guidelines.
That's correct.
So we can accept that as far back as 2004 or 3 that you said you took decision to prosecute in the Chikani matter, the reason why it was not taken to court on time was because you were waiting for the approval of guidelines. Is that not so?
No, that's not so.
But this is what is contained in the report that you presented to the ITT.
There should have been a paragraph before that stating on the 11th of November 2004, the minister phoned the NDPP and says that they should not proceed with the prosecution.
That paragraph was not there. Why didn't you point it out to the ITT that you omitted to include that paragraph in the report that you presented?
I omitted many things in this report.
If you omitted many things in this report, how can we accept that everything that you say here is a complete a set of facts or a true reflection of what happened?
Because I didn't have time to write a 200-page report.
And then you omitted to include certain things.
But what's the important thing that I omitted?
No, I was just asking that you omitted to include a lot of things because you didn't want to write a long report as you put it.
That's correct, that's correct.
And then taking you back to what you said in 4.1.5, you refer to a specific period there to say beginning of October 2006, it was decided to put prosecution on hold. So who decided that the prosecution must be put on hold?
You see, what happened was in 1990 was act or promulgation, something to the effect that all political prisoners will receive amnesty. That was now 1990. And they endeavored, that is now the 3 accused, to ask for amnesty under the provisions of that act. Mr. Who was the NDPP Mr. Piccoli then obtained a legal opinion from senior counsel who says no, they do not receive amnesty under that act. And that is the opinion I refer to.
Okay, so there was a delay that was occasioned by you waiting for a legal opinion in the prosecution of the Reverend Chikane matter?
Yes. But during that same time, you must understand, there was a committee of the NPA who decided on the plea of the three accused, whether they should be whatever, whether we should accept the plea, whether it should be a plea bargaining. That also delayed the matter a long time because I was against such a procedure.
Okay. Before we get to the plea bargain, we can accept that between 2003 and 2006, the reason behind lack of prosecution of the Reverend Chikane matter had nothing to do with political interference. Can you accept that?
No.
But this, I'm basing it on what you presented, that because of, firstly, the amendment to the prosecution policy, you had to stay the prosecution pending.
That's
that.
correct.
That's number one. And then secondly, you had to obtain some legal opinion before you could proceed. Is that not so?
That's correct.
So that could not have been political interference.
Well, the political interference was relating to all my cases, not only the Chikane matter. There were at least 5 cases that had to be investigated by the police.
But what we are saying here, you cannot say the police interfered with your prosecution during that period or the investigation for that matter, because on your own reasoning, you had to suspend the prosecution based on the new amendment or the amendments that were coming in terms of the prosecution policy. And then subsequently that had to do with the issue of the legal opinion that you had to obtain.
Yes, but not me. I wanted to proceed, but they took that point.
Okay. Legal opinion, who requested legal opinion?
Beg your pardon?
Who requested a legal opinion in the matter?
Mr. Piccoli.
Okay. And that was your direct supervisor at the time?
That's correct.
Okay. There are also allegations that the Reverend Chikane matter dominated the discussions in the ITT.
Yes, that's very important.
Is it your version that it dominated the ITT discussions?
That's correct.
If I may refer you to ITT meeting of the 6th of November 2006.
What is it?
And that is page 18 of bundle, same bundle that we refer the commissioners to, the same one of SAPS index relating to Ackerman's cross-examination.
That's correct.
Yeah. The ITT meeting of the 6th of November. You have it in front of you.
I have it in front of me.
If I may point you to the last paragraph. Unfortunately, the minutes are not numbered.
Yes, no, the last paragraph, I know,
On
where the
page
Reverend
18.
Chikane, yeah.
Yeah. Can you read out where it starts? It is, however.
Yeah, very important paragraph. It is, however, worth mentioning that when Advocate Ackerman informed the meeting that the decision to prosecute has already been made by the NDPP on the Reverend Shakani case, Josiah, that's a policeman, indicated, and that's important, that, that the recommendations of the task team are necessary because the National Commissioner is of the view that Reverend Shikani is not interested in a prosecution of the matter. He suggested that contact has to be made with Reverend Shikani to ascertain his attitude.
And then, according to Advocate Ackerman, proceed.
Um,
Oh,
sorry, Ms. Ranto. Mr. Ackerman, do you have before you the handwritten?
yes, I have it. There's handwritten the following underneath it, and that is in, I know that handwriting, it is Commissioner Jacob's handwriting, where he says, Ackerman also informed that NPA discussed the matter with Reverend Shakani.
Yes.
Yes, and this was on the 6th of November, 2006. Yes. Is it correct that you had discussed the matter with Reverend Chikani?
Let me see, what is that date? No, what happened, it must have been 2003. I had a long telephonic discussion with Reverend Shakani, very friendly conversation, telling him that I'm going to prosecute in his matter, and he was very happy that this is going to happen at least, and he thanked me for my work, and that was in 2003. I discussed it with him. But subsequently, you asked me whether I've discussed it with him at this stage or
No, it's fine. You just explained that previously you had discussed it with
yeah,
Reverend Chikani.
yeah.
Perhaps if you can just read the very same paragraph, the next one, according to Advocate Ackerman.
According to Advocate Ackerman, the complainant indicated that he leaves the matter in the hands of the NPA. It was then decided that the latter's attitude be ascertained and the matter was therefore closed pending feedback on his attitude.
Okay. So from the minutes, it is stated that that matter was discussed on that day and it was closed pending feedback from those that would meet Reverend Chikani, isn't it? That would consult Reverend
No,
Chikani.
the matter was not closed. What was?
It was not closed from the ITT side. Remember, we're talking about the
No, it
dominance.
was not closed. It features a lot. There are many times that I was told, and Corley was told, that I must have a consultation with Reverend Shikani, because in terms of the guidelines, the amended guidelines, I have to have a consultation with him.
I'm saying that because you said the matter dominated the ITT, and I was
That's
saying
correct.
now, the first time the matter was discussed was 6th of November 2006. Would you agree? That's now by the ITT.
Let's have a look. May I have a look?
Yes.
I have a look at it. Well, that was the second meeting of the ITT. The first meeting, nothing happened actually, except to say we must present audit reports. Yeah. The 25th of October was the first meeting. Let me see. There must have been, well, there was a meeting, and at that meeting we were told to present audit reports. I had to PCLU and the police, and I presented the report, And this is now the third meeting
Okay.
about
and that-
Chicano.
No, that was the third meeting of the ITT,
Yes.
but I said, I asked you if you agree that the matter of Chikani was first discussed on the 6th of November 2006, meaning it never dominated the discussions on the first meeting of ITT on the 12th, and then the one that said also on the 25th of October 2006.
I think there was another one, but certain. There was discussed. And
All right, let's go. If I may assist you, the second discussion,
no, you know, on the 29th of January 2007, there was another discussion. It says the following, do you have, it's on page 24.
okay. So
Do you have page 24?
I don't have it, yes.
Okay.
I'm with you.
Now let me read you out what happened on the 29th of January 2004. The third
29th
paragraph,
Wait now.
2007.
29 January 2007.
That would be on page
2007.
24.
Yes.
Commissioners is on
But
page
it-
24.
Mr. Advocate Ackerman said 2004.
Oh, okay. It's
Oh,
29
sorry.
January 2007, Commissioner Sees.
is that the correct? Yeah, that's correct. Now, the third paragraph reads as follows. Advocate Ackerman requested members for the input with a view to finalize the draft report submitted to the National Director. Commissioner Jacobs indicated that he was made to understand that Reverend Chicani was not interested in the prosecution of the accused in his case. Therefore, he needs to be consulted and the matter needs to be discussed with their principals before making recommendations. Advocate Ackerman reminded the meeting that the National Director has made his decision on this matter. Yvonne concurred with Commissioner Jacobs on the Reverend Chicani matter. On Ngidi, however, had no objection to the National Director's decision on the Reverend Chicani matter. That's about 3 pages of a 5, I mean, it's 3 paragraphs of a 5 or 6 paragraph meeting. That's why I'm saying it played a very important role.
Yes, but not in all meetings.
Dominated. It
Not
dominated.
all meetings. It was not in all meetings. It did not dominate all meetings, isn't it, Mr. Ackerman?
There were 5 meetings.
Yes, but of the 5 meetings, you only referred to 2 meetings where the Chikani matter was discussed. Out of 5?
Yes, it dominated.
So it could not have dominated all the meetings. Would you agree with me?
Yeah, dominated 2 meetings.
Okay, thank you. And then there's a meeting with Reverend Chikani that you and Advocate Mohaga attended.
That's
You
correct.
testified to that, Advocate Mohaga also testified to that, and that meeting took place on the 22nd of January 2007, according
That
to
is correct. Yes,
And-
that's correct. I recall that.
And that would have been some few days before the sitting of the meeting of the ITT on the 29th of January 2007. You agree?
That's correct.
Did you then disclose during the ITT meeting on the 29th of January 2007 that you had a meeting with Reverend Chikani a few days before that meeting set?
No. If it's not fairly no.
Any specific reason why you did not disclose that?
I can't think of a reason now, but probably I didn't want to tell them what Chani told me and what happened there.
The question is whether you told them.
No, I did not.
You did not tell them. And that meeting, if you look at the minutes of the 29th of January, the one that you referred us to, the 29th of January, 2007.
You know what? Is that date correct?
Yes, it's 29 January 2007.
Yeah. I'm listening.
If I take you to, I think it's paragraph 1, 2, 3 of the same minutes of the 29th.
Yeah.
Yes. You see where it starts with Advocate Ackerman SC requested members for their inputs with a view to finalize draft report submitted to the National Director.
Yeah.
And then it reads, Commissioner Jacobs indicated that he was made to understand that Reverend Chikani was not interested in the prosecution of the accused in his case. Therefore, he needs to be consulted and the matter needs to be discussed with the principals before making recommendations. You see that?
That's correct.
And the next paragraph reads, Advocate Ackerman SC reminded the meeting that the National Director has made his decision on the matter. You see that?
That's correct.
Now, question is, when General Jacobs or Commissioner Jacobs said that he was made to understand that Reverend Chikani was not consulted or not interested and that there needed to be consultation, why did you not see the need to point out that you had a meeting with Reverend Chikani a few days before the meeting set?
I don't know, but perhaps I then had to explain what happened there.
What happened in that meeting with Reverend Chikani?
Well, as I stated in my affidavit, I cannot recall everything that happened there, but the bottom line was he didn't say, I want the prosecution, and he didn't say, I'm against the prosecution. He said he is in the middle, in a battle between the government, I think, and the NPA. Now, I know what that battle is. The government wanted him to say he's not interested in a prosecution, whilst in fact, I think he wanted a prosecution. And that's why he didn't want to say anything. And I'm also of the view that the commissioner went to see him quite a few times. In any event, there are many other things that happened that I don't want to disclose now, except if you ask me.
Well, of course, I would want to disclose what happened in that meeting.
You can ask Mark. I said, I cannot recall everything. I think what happened at some stage where he said he's not interested in the prosecution, I said something, well, you know, in terms of, you will be subpoenaed in terms of section 179. And, you know, I could see he was not happy about that I said I'm going to subpoena him, and that is the reality. I explained to him the Criminal Procedure Act, the procedures, and he was not happy about that. I see in his affidavit or statement somewhere he stated, I warned him in terms of section 204. Section 204 is not relevant.
So your reason for not disclosing it to the ITT, what was the exact reason for not disclosing your meeting? You didn't have to tell them what happened, but just to inform the ITT that you had with Reverend Chikani.
I tell you what, of course then they will go back to the directors and tell him, yes, Mr. Chikani, Reverend Chikani says he's not that interested, but he doesn't object. Or I don't know, you know, if I tell them, I don't know what they're going to tell the puppet masters.
You were a participant in the ITT, advocate. You were one of participants in the ITT.
Yes, that's correct.
In your official capacity.
That's correct.
Did you participate in good faith during that period?
Is the question whether I agree with the amended policy guidelines? Is that the question?
My question is, was your participation in good faith to the ITT?
Yes. The act as it stands, I had to do a job. I was there. Was not happy about it.
If it was so much in good faith, what was difficult just to inform them without interfering with your independence, just to disclose that based on that which was requested previously, that there needed to be consultation with Reverend Chani, you had a meeting with him. That was not disclosed, and I wanted to understand what was the specific reason for you not to take in the meeting into confidence that you had a meeting with Reverend Chani few days before the meeting said.
I was of the view that it will cause too much interaction with them.
Yes, before you carry on this aspect, what I would want to understand is that now with reference to the meeting of the 29th of January 2007, and council asked, why did you not disclose the interactions 2 or a few days before that occurred between you and Reverend Chani? Now, what I want to find out is that I see they, at page 24, there is this list of people who attended this meeting. Now, what I want to find out is that, is there any one of them, Mr. Ackerman, who also attended the meeting that is in question that you have referred to?
Yes, I see it's Mr. Mthunzi Maga.
Okay, Mr. Mthunzi Maga attended that meeting. As far as you can recall, is he the only one who attended the meeting? Yes, but let me ask it this way. Did Mr. Mthunzi Maga disclose what happened on that meeting before the 29th of January 2007? You did not disclose. Did Mr. Mthunzi disclose at the meeting of the 29th of January 2007 what happened?
Well, he didn't disclose it. I may add that, thinking back now, we were not sure of the date we went to see Reverend Chani. I don't know, I specifically said to him, Mthunzi Maga must establish that date. And he said it was the 22nd of January. But looking at it now, there's a possibility that it might have been after the 29th, because if it was before the 29th, I don't know what my reasons were for not disclosing, except if it was not before the 22nd of 9. Maybe it was after the 22nd of January. I'm not sure. I didn't disclose it. And Maga also didn't disclose it.
Yes. Just on another aspect, if you look at page 23, you had asked whether the date of the 29th January 2009 is a correct date. I don't know whether you are confused by the date of the 4th December 2007 because that date has been corrected to the 4th December 2006.
I see that.
Are you aware of that?
I see that, yeah, that's right.
Yes, okay.
But as I said, I don't know if the 22nd of January was in fact the date. I didn't have a date.
Yes. Mr. Ranto, you may continue. Thank you.
Thank you, commissioners. So thank you,
I'll
Mr.
tell-
Ackerman. Yeah, we can accept that both you and Mr. Mahaga did not disclose on the 29th that there was a meeting with Reverend Chani before. I think we can step off that point.
Yes, please, Ms. Ranto, it's quite clear that there was no disclosure.
Note, thank you, Chairperson. And then we can move to a fabricated note that Mr. Ackerman alleged that it was forced by the police to put him in bed light. The fabricated note, remember the memorandum of 2003, but dated 2006, the forged note or fabricated note. You remember that the issue?
Yes, I know the facts.
Okay, you know the facts. We don't have to repeat what was said there. Yeah. Now, if I may refer you to. Oh, sorry, Chair, I don't know. Apparently, Mr. Ackerman has asked as to when we're taking to.
No, I'm fine. I can carry on.
Okay, it's fine.
Are you fine, Advocate
I'm fine and I
Ackerman,
had a
if
good
we
night's
carry
sleep.
on
I'm
until 11 o'clock?
That's fine. I'll carry on. I want to get rid
Thank
of
you.
it.
Thank you, Mr. Ackerman. Your issue or your version about the note, as you say, we know the facts. It's dealt with specifically in paragraph 35 of your affidavit filed in the Gadime matter. That's on page 16, if you need to refresh your memory. But we know that the version that you put before the commission is that that was not your note, or that note that was said to have been compiled by you was not compiled by you. Is that not so?
No, the date was changed. It was not my note.
Now, the view that we expressed in paragraph 13, I'm sorry, 35, that I referred to, that's your affidavit of, affidavit of 2015, the one you filed in the Gadime matter. So that is on page 16 of your bundle. You state that I believe it was aimed at discrediting me and ultimately stopping the investigations of the TRC. And then I'm firmly of the view that the National Commissioner, the late Mr. J. Selebi, played a conspicuous role in claiming that I was pursuing the said leaders. Now,
Yes.
yes, I want to understand what informed you that it was the late Commissioner Selebi that was behind the allegations that you fabricated the note. What informed your view?
He was the I can't talk. It's an echo all the time.
Yes, we will attend to it, Mr. Ackerman, when we adjourn at 11 o'clock. But can you hear what the question was?
National Commissioner Selebi had an obsession stating to everybody and every politician he saw that that's Ackerman is investigating the ANC 37 leaders. We have written to the minister, to everybody. There was a press release to the effect that we are not investigating the president. But Mr. Commissioner Selebi carried on about this matter. And if you remembers Mr. Simelani's evidence, how they said they must get rid of me. That letter was produced. I'm of the view that there's a memorandum by Commissioner Jacobs setting out that I am still investigating that matter. And when Mr. Celebi said that he has a letter in my own handwriting with him, I speculating, showing that document to the ministerial committee.
Okay.
So
Let's
that's
go
why
back.
I'm of the view that but it was somebody from the police. There's no doubt about that.
My question was, Mr. Ackerman, what informed the view that that very same someone was the National Commissioner, the late Commissioner Celebi?
I told you now why I think. He was in need of a document to prove that I was still investigating the ANC 37 in 2006.
What evidence did you have that it was him that was responsible for that?
Okay, perhaps I should rephrase it then. It was the police, it was the Commissioner of Celebi, that was Mr. Bester, Colonel Bester, or that it is Commissioner Jacobs and or Brits that forged that letter, because the persons had technical knowledge. They hacked my computer and put that same letter in the computer, on my computer, that forged letter. So it was the police. You can make your choice who you think it will be.
So I must make my choice. You are unsure as to who exactly was responsible for that.
You asked me to speculate. I think it's Commissioner Celebi, because he was the person interested in that forged letter. He needed it to prove I was still investigating them.
Can we accept that there was no evidence that you put before the court to support that allegation? Even today, there's no evidence to support that Commissioner Celebi was behind what you alleged was behind your orchestration.
Ms.
You want me to
Rantu-
start from-
Ms. Rantu, I don't want to interfere with your line of cross-examination, but isn't that quite clear that there is no evidence? He said it is his opinion.
Perhaps, Chair, what I was trying to establish, I may have overstretched it, but I wanted to understand what informed his opinion, because it is before the commission, it is before the court.
Yes.
So I needed to understand, but I suppose the witness cannot tell as to what informed. He's
Yes.
speculating. I can
Yeah.
accept it.
Thank you.
Chair. Yeah. Okay, we may proceed on that issue, but of the Commissioner's levy, but we are still dealing with the forged note, Mr. Ackerman. Now, if I may refer you to, it's Ackerman's bundle, additional bundle 3 of Ackerman, page 108.
It is correct.
Yeah, that document, perhaps if you may, we may start on page before page. Commissioners, this document is just titled Commissioner Jacobs' affidavit. It looks like it's some notes that were prepared in response to Commissioner Jacobs' affidavit that was before the General Commission. Now, I'd like to refer the witness to page 108 of that document that is titled Commissioner Jacob's affidavit. It starts on page 105.
Which bundle?
Additional bundle 3. I think it's called additional bundle 3 of Ackerman.
Yes, I have it with me.
If you can just read it out, just paragraph 18.
18.
18, 1-8.
Okay, well, I'll do it. On the 17th of September 2007, SAPS informed Advocate McCarthy that the office note had in fact been created in 2003. It is now common cause between SAPS and the NPA that my office note was written on 26th of June 2003 and not 26th June 2006.
But perhaps if you may first confirm that this document was prepared by, or was prepared in response to Commissioner Jacob's affidavit that was before the General Commission. Is that not so? In other words, Mr. Ackerman?
Yes, it looks like it. No, I think it was Mr. Piccoli who asked me, but no, I don't know. I just want to read. Yeah, that is his affidavit before the Douala Commissioner.
Yes. And before this commission, a question was asked based on the version that you put before General Commission in relation to the forged note. And what you stated in the General Commission, what you said was that it is now common cause between SAPS and the NPA that my office note was written on the 26th June 2003 and not 26th June 2006.
Yes.
And when the question was asked before this commission as to why you said that before General Commission, your answer was that you could not explain why you said that before the General Commission. Remember that?
Yes, this echoing is affecting me. I can't talk.
This
carry
echo is
on.
affecting you. Miss Advocate Ackerman, would it be a convenient time to adjourn now so that the echo can be attended to?
I appreciate that.
Yes. We'll take a 15-minute adjournment, in which case we'll reconvene at 5 to 11.
Thank you, Commissioners.
Could somebody please attend to the echo? Ms. Ranto, just some housekeeping rules. How long are you going to be in the cross-examination of Advocate Ackerman?
30 minutes would be too much.
Thank
Chair.
you.
Yes. Thank you, Commissioners. If I may proceed from where we left off with Mr. Ackerman about the statement he made during the Genoala Commission about the forged note. Do you remember, Mr. Ackerman?
Yes, first of all, I didn't give evidence at the, it's echoing again. I will try and speak. So listen carefully. I did not give evidence at the Ginwala Commission. This letter, this documents from 105 to 109 is a document that the NDPP asked me to comment on. It was the affidavit of Commissioner Jacobs at the Ginwala Commission, and he asked me to comment on what what the commissioner said. So at the bottom then at page 108, paragraph 18, I said on 17 September 2007, SAPS informed Advocate McCarthy, didn't inform me, that the office note had in fact been created in 2003. So when I wrote this document, compiled this document, it must have been now some time after the 17th. What is, however, relevant is page, we can take it 145, or I see a document that I wrote to Leonard McCarthy. Do you have it? Page 145. But I saw it somewhere else too. It's also page 119, same document. Have you got it?
Yes, I have it. Thank you.
Can't hear you.
I have the document, Mr. Ackerman. I'm
Okay.
trying to understand.
That document was written on the 27th of September 2007. Why I wrote to McCarthy was I was told to present him with advance reasons why I should not be prosecuted for perjury. So I wrote this to him, and that's now the 27th of September 2007. But when I wrote the document on page 107, I must have been after the 27th of September, obviously. I then found out that on 17th September, SAPS informed Advocate McCarthy that the office note had in fact been created in 2003. So you must understand, I'm now very cross that I must advance reasons on the 27th of September 2007. So when I probably read this or stated it at some stage about the 17th of September, it also didn't make sense to me. And I think I said it doesn't make sense to me. Now it makes sense to me. It was not stated to me. The SAPS informed McCarthy, and I established it after the 27th of September. Does that make sense?
Not at all, Mr. Ackerman. I think with what you said, what I was trying to establish from you was why when you prepared this document, and thank you for clarifying as to what the status of this document is. But what you said then, as you stated earlier that you were preparing this for Advocate Piccoli, you said that it is now common cause between SAPS and the NPA that my office note was written on 26 June 2003 and not June 2006. So it's common cause that the one that you say it was common cause with the SAPS, that your document was written on the 26th June 2003 and not June 2006. Now the question is, when you prepared this, why did you not advance that accusation that it wasn't the same document in terms of
I don't know
what you are now informing the commission is that that document, you disown that document. In actual fact, if I may take you to your testimony to say that at that time you established that your computer was hacked because that very same document with the same date was found in your computer. And what you inform this commission is that you believe that your computer was hacked. The police made sure that that document is somehow installed or put in your computer in your office. Remember saying that, because your evidence is that this document was found in your computer. Is that not?
What's the point you're making?
The point I'm trying to find out is that when you compiled this document, you said it is now common cause between SAPS and NPA that my office note was written on 26 June 2003, right? And not 26 June 2006. That we know that it is a dispute. You say the document that the police had cannot be yours because yours
Yes.
was drafted in 2003. We agree on that one, isn't it?
That's common cause, that document was written on the 2003. You agree that document has been forged?
I do not. We'll get to the forgery part of it. The issue was your status in relation to whether or not that document was indeed prepared by you or authored by you. Because before this commission, you deny that you were the author of that document in the first place.
Are you talking about the 2003 document or the 2006 document?
The one that was found in your computer, what date was that?
2006.
That's the one that was found in your computer.
That's correct.
Yes. That's the one that you say here, common cause that it was written on 26 June 2003 and not 26 June 2006. So that means it's the same document. The issue could be the date. No, the issue, according to what we are stating here, if I understand you well, in the document that we prepared for Advocate Piccoli in preparation for the Ginwala Commission, as you said that it was to assist in responding to General Jacobs. Let's go back. Remember, we're going back to paragraph 18 of the notes or whatever that document you named it, the one that you prepared for Advocate Piccoli in response to Commissioner Jacobs' affidavit that served before Ginwala Commission. You remember that document on page 1?
Just ask me, there's so many questions.
Okay, I'll go, yeah, I apologize for that. Let's go back to page 108. The problem, Mr. Ackerman, you don't give too many answers because we are going to be confused. You're going to lose me, I'm going to lose you as well. Let's go back to page 108. 108 of additional bundle. Yeah. Remember, you just corrected that in actual fact that was not in reference to the affidavit that, or in actual fact the evidence you gave to Ginwala, but rather you said this document is what you prepared for Advocate Piccoli when he was going to appear before Ginwala Commission. This document.
Is to give him some background on the forgery.
Yes, correct. Now, in you giving him background on the forgery, right? On page 108, paragraph 18, paragraph 18, the one that you read out.
Yeah.
You informed Advocate Piccoli that it is now common cause between SAPS and NPA that my office note was written on 26 June 2003 and not 26 June 2006. Right?
Yes, but that's what McCarthy informed me. Read that.
So this is what McCarthy informed you.
Yeah, that it is now common cause. And can you understand how cross I am that on the 27th of September I must advance reasons why I would be prosecuted, be charged with perjury.
Okay, all right. General Jacobs gave evidence before the commission. I'm sure you must have gone through his affidavit, but I think most importantly, annexed to the supplementary affidavit, the main affidavit was the expert report regarding the forged note. You remember? There was forensic analysis of the forged or alleged forged document. Remember?
Yes.
Yeah.
Yes.
And your testimony is that you do not agree with the outcome of the expert report. Is that not so?
Definitely.
Were you trained in handwriting expert, or do you have any expertise in handwriting?
You don't have, if you look at the cases, any person is entitled to make a finding on handwriting.
Okay. Now, as a prosecutor, seasoned for many years as a prosecutor, you have made use of expert evidence, isn't it, in your career, during your career?
Many a time.
And then what would you use to counter any expert evidence that is put before the court or any fora?
Do you want me to say I go to a handwriting expert?
No, what I want to understand, for you to dispute the evidence of an expert as a career prosecutor, what would you do to dispute that which is placed before the court as expert evidence?
Can we just have a look at the photo of the six?
Just answer my question first. Before we go there,
Yeah.
you have said you're not an expert in handwriting, isn't it? You're not a handwriting expert. We can accept that, okay?
Yes.
Now, the second question that I asked you was whether during your career as a prosecutor, you ever made use of expert evidence, and your answer was yes, right?
Yes.
And a simple question that I wanted to, an answer I wanted to elicit from you was, what kind of, or how do you deal, or how do you dispute expert evidence that is before the court? In other words, what do you put before the court to convince the court that that expert report cannot be right?
Well, the expert report we have before us does not state that the six has been forged or not. Nothing is stated about the six.
But you accept that this is an expert report. This is a person
Yes,
who
and
conducted analysis was an expert.
I'll say this under oath, that they must call that expert and give evidence, and he must be cross-examined on his report.
I will accept that, but you now, you are faced with that expert report, and I'm saying to you, you are not in position to dispute because you are not a handwriting expert. Is that correct or not?
I know that handwriting is not mine because the person who typed that document was not even there.
That you know, but,
So,
but you are not in position, or you are not capacitated to dispute what an expert says in his report. Is that yes?
I dispute what that expert says.
In this case, you dispute
Yes.
based on your own opinion.
No, on common sense.
or common sense. Thank you. But you cannot dispute it in line with
I
what...
dispute it.
No, remember I took you back to your days of prosecution when I asked you a simple question: how do you deal with expert evidence? And you have not succeeded in answering. As a prosecutor, for a moment, forget about this particular footnote because it's too personal. You, during your time or times as a prosecutor, what would you do to counter evidence that is put before the court by an expert?
I will cross-examine him. I've cross-examined many an expert and prove that they are not credible, that they haven't got the expertise, and that they had the motive to give a false report. That's why I state that the TOI must come and give evidence at this commission so that he can be cross-examined on his expertise and his findings. Because you must understand, he's also a policeman. He's doing a report for the police.
What do we make of your version that that same document dated 2006 was found in your computer?
It proves that there was some person that had the technical abilities to not only change that document, but put that document on my computer. But he made a grave mistake in that he didn't know that Tia Pina was not, I don't think she was even alive in 2006.
Thank you. We will argue in closing or at the end of this commission that your version in relation to the forgery is far from the truth, Mr. Ackerman. But
So
no,
may
that
I
is
ask,
just we are just commenting. We will argue that with the facts that you put before to counter that which the experts have put forward, we are saying your version cannot be probable. It's far from reality.
Mr.
That's just a comment.
Ackerman, it's a comment. It doesn't require your response.
Then the last thing that we deal with is just the issue of the presence of intelligence structures in the ITT. There are allegations that one of the pointers to political interference was the presence of intelligence structures within the ITT. In other words, the officials that came from ordinarily would be, as explained by General Jacobs, is crime intelligence, national intelligence agency at the time, and defense and military intelligence.
did I give that evidence?
I beg your pardon?
Did I object to their presence?
What-
Mr. Ackerman, just wait until the question is asked and then respond.
Thank you, Commissioner Khoma. The allegations before this commission, Mr. Ackerman, are that one of the things that pointed to political interference insofar as the prosecution of the TRC cases was concerned was the presence of members from the intelligence community, if I might put it that way. And I know there is a specific reference in the Galata affidavit. You also supported them that Mr. Jafta, who was at the presidency at that time, I think to name but few, he's one of people that were fingered that he was there as a person from the intelligence community. And now I want to deal with the
From
presence
the
of...
intelligence if I may
if-
just get clarity, Ms. Rantu, without interfering with your line of cross-examination. Ms. Jafta, was he present as a member of the intelligence committee or as a person from the presidency?
Thank you, Chair. Perhaps if, yes, in intelligence structures. The allegations in the Galata founding affidavit supported by Advocate Ackerman are that there were members of the intelligence structures.
Yes,
And Mr. Jafta also is fingered, even though he was in the presidency.
yes,
And that is why I think in General Jacob's affidavit, it is explained that Mr. Jafta at that time was actually in the presidency.
yes,
Yes.
yes.
But more specifically, just to confine it to those ones that we know that they were there in their capacity as members from intelligence structures.
Yes,
I think Mr. Ackerman would recall that you had a number of them, the Kalakala, Mabule, you name them. Remember that, Mr. Ackerman, that they were
Yes,
part of
yes,
the
I know.
Yes. Now, I want your response in light with what is contained in the ITT minutes of the 16th of November 2006.
Which page?
That would be page, is page 21 to 22 of what we titled SAPS index relating to cross-examination of Advocate Ackerman. So that would be page, it starts from page 21 to page 22. Those are the minutes of the ITT of the 16th of November 2006.
Yes, I have it.
Yes. Maybe before I take you through to those minutes, do you agree that there was nothing wrong with the intelligence officials being present in the ITT meetings?
No, in fact, it's in the guidelines that they must assist me.
So anyone who says that pointed to political interference would be incorrect, right?
If they interfered, I don't know if they interfered. In fact, I had a one-on-one meeting with the officer, the person representing national intelligence. I think it's Yvonne. I sat there an hour with her and explained to her what I need from her, and I gave her my views on what the only case of all the cases that I have might be of importance. I think it was a Powell case. And I said to her, she must not get too involved in the investigations. She must leave that to the police.
So there's nothing
And
wrong.
by Yvonne, you refer to Yvonne Mabule.
Yvonne Mabule is.
Yes.
Thank you for that. And then the last thing is the letter of Commissioner De Beer. Remember your interaction with Commissioner De Beer about the assignment of investigators?
Yes.
And
Well, which letter is that? Is that the one of September,
26
August?
Yes, the 26th
No,
September.
I don't know that one. Can you refer me?
That would be, the September one is page 296 of the Galata bundle.
6.
296.
Just having a look.
Is dated 26 September 2003.
Yes, not 2006.
Yes, yes, yes. Remember, you agree that this letter was addressed to you by Commissioner De Beer.
Yes.
And in this letter, it is clearly stated that the police were of the view that the president had to clarify the mandate insofar as the TRC cases were concerned, isn't it?
That's correct.
And then the allegations made in the Galata bundle are that that letter of De Beer pointed to a refusal / interference of some sort. So it's part of the chain, although it's not specified, but it seems to form part of the chain of the political interference. Now, insofar as you are concerned, in your affidavit of 2025, I want to refer you to a specific paragraph in relation to this letter of De Beer. Okay? You follow?
Now, where's my...
Affidavit, that would be Bundle 3, Anton Ackerman, that would be on page 24, paragraph 17.
Paragraph 17. Yes, you say paragraph 17.
Yes. What you are dealing with in terms of, sorry, your paragraph 17, you'll see preceding paragraphs there, you are referred to certain paragraphs 195 to 6, failure to create mechanism and to approach the president. You see that?
Yes.
Now, paragraph 17, going back to paragraph 17, in your affidavit, you say, I agree that government failed to take steps to investigate the TRC cases. I also
Yes.
agree, yes, and you say, I also agree that the president should have been approached. You see that statement?
Yes.
18, as I was not the NDPP, it was not within my prerogative or power to contact the president, right?
Yes.
And that is your statement.
That's correct.
Am I then correct to say that you did agree with Commissioner De Beer that there was a need to consult the president to clarify the mandate in terms of the proclamation as to the SAPS now being the ones to take over?
That's not on my scale to approach presidents. I just wanted the investigating agency, and you have two investigating agencies, and not one of them wanted to investigate.
So you agree there was a need for the president to clarify that? Yes or no? Did you agree
You know-
with De Beer that there was a need of the president to be
Well,
approached?
my boss, the National Director of Prosecution, did not think it was necessary.
Did you agree that the president had to
I
be
would have.
approached?
I would have.
So if you were in the shoes of the NDPP, you would have approached the president?
Yeah, if it was within my powers to approach a president and say, please assist me with TRC prosecutions.
Thank you. That,
Thank you, Ms. Ranto.
okay, may I just a few minutes, sorry, Chairperson,
Yes.
I may have, let me get some. Oh, yes, maybe, no, I think the issue of, I don't think so. Oh, yes, sorry. A very last one, Chair, this one is important. Thank you for that, Mr. Kofi. The testimony by Mr. Ackerman that while presidential authorization was sought, the SAPS had no objection to continue with the APLA and MK investigation, which showed cooperation by SAPS. And that is found in the transcript of the 4th of March, that's on page 43, from lines 19 to 44. And then that is included in the SAPS bundle page, that's now 78 of the subs bundle that we prepared, page 78. So, just let me take the transcript. Here, Chairperson, we simply wanted to confirm what was said by Mr. Ackerman to say that, yes, it's on page 79 of the bundle that is before the Chair, where just before, it's line number 44, just on top there. And this was Mr. Ackerman who said, SAPS would not investigate unless the president authorized it to do so. There was, however, no objection to SAPS continue with the APLA and MK investigations. Relevant correspondence is attached. That was the testimony of Mr. Ackerman, saying that in actual fact, there was no objection by the SAPS to continue with apply an MK investigation. Remember that, Mr. Ackerman?
Can you refer me to paragraph 10? I say, Mr. Barney says, if we can just pause for a second, just a question for clarification. So in that paragraph 10, you seem to say, now, can I have that paragraph 10, please?
Yes, I have it. You can read it
No,
out.
where is it?
It's in the band, it's paragraph 10, page 79. Or paragraph 10, is it of this affidavit maybe?
Oh, there was ever no objection. But can I just have the paragraph 10 in the letter? I don't know where the letter was. Let me just read it so that I can see in context.
We just need, no, we don't have it. Okay. But nonetheless, I don't think it's changing the fact that you are saying you would have approached the president nonetheless. And maybe just to sum it up, from the letter of Commissioner De Beer, you would agree that in the same letter, he does indicate the willingness to assist, albeit with clarity being sought from the president. Is that not so, Mr. Ackerman?
You know, what I read here is the following, and that's from page 78. After I put in my request, he in writing advised me that SAPS would not investigate unless the President authorized it to do so. There was, however, no objection to SAPS continuing with the APLA and MK investigations. Relevant correspondence is attached here too.
Meaning, on your own version, there was no objection in the meantime, whilst clarity was being sought. That the
Now, I get the impression that he said that to me. I don't know where's the letter, can I?
What you stated here is that, in essence, notwithstanding the issue of the clarity that had to be sought from the president, the SAPS continued with investigations against or involving APLA and MK.
Well,
So there
you
was some
stated that
progress being made.
I haven't seen it now, but you
I'm
say.
sure you can safely take that in argument.
Okay, thank you, Chair.
Yes,
Yeah, that brings an end to our cross-examination, Chair.
thank you. Mr. Kwala?
Thank you, Chairperson.
Yes, I think you should do it now. It's convenient. I think it will be convenient, Mr. Vani, to do it now and not wait for a host of cross-examination to be conducted by the parties.
You were referred to an audit document that you prepared for the task team. It was addressed to, I believe, Dr. Ramaita. It's dated 24th October 2006, and it's on page 8 of the SAPS bundle. Do you have it? Perhaps Mr. Venter can help at the SAPS bundle, page 8.
Yes, page 8. Yes, I have it.
You referred to paragraph 4. It's titled Potential Prosecutions Identified by the
Yes.
PCLU.
Yeah.
Am I correct in saying that this audit document did not purport to be full reports on each case, just just the highlights.
Of course, yeah. It's not a full report.
And just to remind ourselves, this was an October 2006 document, so some 2 years after the incident in relation to your attempt to carry out the arrests in the Chani matter.
Yes.
Now, you were referred to paragraph 4.1.1, which reads, indictment already drafted in 2004, prosecution was put on hold pending approval of guidelines. Now, it was suggested to you by my learned friend for the SAPS that because you had not indicated that the minister had intervened in the matter, that perhaps that did not take place. You recall?
Can you just repeat that, please? I'm reading it well.
The criticism was made in cross-examination that if the minister had intervened, then it should have been included in 4.1.1.
No,
Sorry.
this is not a
Sorry,
full
Chair.
report. Yeah.
Sorry, Chap. Sorry, Mr. Vani. Chair, there was never such. We never cross-examined along those lines. Failure to disclose that we put to Mr. Ackerman had to do with his meeting with Reverend Chani. The only question that was ever posed in relation to the Chani matter, it related to the period of the prosecution when I was trying to establish when was the decision to prosecute taken, and he said, and he even further then said, then the minister intervened. The only question was then, when was that intervention? That's all, but it had nothing to do with the issue of the meeting with Reverend Chani. So I simply wanted to just to correct the
Yes, Mr. Vani.
Yes. Well, thanks for that helpful intervention. If my learned friend is not disputing the minister's intervention, then I'll move on.
Yes.
So if you come.
Then if we can move to your paragraph 33, and there was a suggestion by my learned friend for the SAPS that you might have been mistaken in relation to a letter from Commissioner Jacobs in relation to the task team submitting a final recommendation to the Committee of Directors General, who must in turn advise the NDPP before he makes a decision. You recall that exchange?
Yes, yes.
Yes. Now, you then made reference to email exchanges between Assistant Commissioner Jacobs and Mtunzi Maga, but I wish to refer you to a letter that was prepared by Assistant Commissioner Jacobs in the name of National Commissioner Selebi. It's dated 6 February 2007. Commissioners, this letter is in a few bundles. The one I'm looking at is bundle 2 of the Kalata Group. That's bundle 2 of the Picoli papers at page 172. I believe it's also in the Jacobs bundle as well. Do you have a copy of that letter?
I have it here in front of me now.
Can you read into the record, for those who don't have it before them, the third paragraph, but just before you do that. So this is a letter from National Commissioner Selebi to Advocate VP Picoli, NDPP. It's dated 6 February 2007. And if you look at the bottom of the page, there's a reference which begins PCJ. Would PCJ indicate that that was written by Assistant Commissioner Philip Jacobs?
That's correct.
Then just for the record, to clear up this confusion around the letter, can you read into the record the third paragraph?
Starts off, I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Directors General will have an opportunity to provide input before a decision on prosecution is taken.
And then can you read the fifth paragraph, the last one on that page?
My understanding was that the officials designated on the task team by the Directors General will provide recommendations to the Directors General, who will, as a collective, advise the National Prosecuting Authority as the decision maker on prosecutions.
And finally, can you read the second paragraph on the next page?
Although I do not insist on a meeting of the Directors General after each meeting of our officials, I deem it necessary that the substantive report and recommendations of the officials should be discussed by the Directors General before a decision is made.
So is it likely that this is the letter you were referring to?
Most likely must have been this letter, because I know at some stage I was informed that I received a letter.
And then if I can refer you to a question that was put to you in relation to what was taking place between the years 2003 and 2006. And I believe it was suggested to you that what was happening in relation to the Chani matter and others had nothing to do with political interference in those years, at least in relation to the role of the SAPs. Am I correct in saying that it is your evidence that the police were not investigating the Chani matter or other matters during that period?
I didn't investigate any matter during that period that I know of.
And then if we can turn to the task team meeting of the 29th of January 2007, there were some exchanges around the question of consulting with Frank Chani, the Reverend Frank Chani, in relation to the prosecution in his case. You indicated in that meeting that the NDPP had already taken a decision to prosecute in that matter. Just for the sake of absolute clarity, what is the role of a victim or a complainant in a decision to prosecute?
Are you now talking about TRC matters?
No, any matter.
The prosecutor did not consult with the victim. But it's advisable that it is done, that you consult with the victim. But I already knew that Mr. Reverend Chani was going to say that he's not interested in consultation. What happened was in the
Let me not interrupt you. Sorry to interrupt you. I just want to save some time, Advocate Ackerman. Let me put it this to you. If the victim says he or she doesn't want a prosecution, is the prosecutor obliged to follow that request?
No.
Thank you. Let's move on. Various questions were put to you in relation to the forged document. Now, as I understand, your evidence in relation to the various file notes that were put up, I believe in the General Jacob's volume, and there are one or two in the SAPS bundle as well. Is it your evidence that those file notes or memos, file memos, that the name of the typist is the typist who was working with the PCLU during 2003, but who had left the organization by 2006?
No, she left the organization in 2003. In 2003, beginning 2004.
Yes, so she was not around to do typing in 2006.
Definitely not.
And the phone number that is depicted on those file memos, that phone number, is that from your office in 2003?
You asked me no question. I know there was, I don't know if that is perhaps Chris McAdams' number. I'm not sure, you know. It's a long time ago.
Well, I understand in your evidence in chief, and my colleagues will have to find it, that that number was operational in 2003, but not in 2006.
That's correct. That must be McAdams' number.
And then just turning to the deliberations around Assistant Commissioner De Beer, Head of Detective Services, there was many exchanges around whether the President should be approached, as suggested in his letter. Now, in your second statement, you said that you believed the President should have been approached. Am I right in saying that you indicated this was not because you agreed with De Beer, but you simply wanted to get the investigations off the ground?
Of course, it's correct.
Thank you. No further questions, Chairperson.
Thank you, Mr. Vani.
Mr. Vani, just there, I'm not so sure whether I'm even confusing myself, but is there historically the document of June 2003, does that document exist, and has it changed hands with the date? Is it 26th June 2003? Is there such a document? Because I want to try and understand the appearance of the document of the 26th June 2006. So historically, does that document exist? The document of the 26th June 2003. And if it existed, can we locate it, or what is the position? Can the witness help?
Yes, Chairperson, my understanding of the evidence of Mr. Ackerman is that that file note did exist in 2003. I'm not aware, we can ask Mr. Ackerman whether it exists in hard copy, but it certainly existed on his computer. And Mr. Ackerman alleges that his computer was hacked and then adjustments were made on it for the purposes he suggested.
Yeah. Mr. Ackerman, I only want to fasten on the document of the 26th June 2003. Is that document in existence somewhere? And has it changed hands?
Commissioner, when I received the document from Commissioner Jacobs, I saw that the date was that. I then immediately said to my secretary, get me the document on my computer. And when she went to the computer, the document has been amended on the computer to 20,026. And suddenly, all the other documents from A1 to A17 were all reflected as 26 June 2006. And of course, that is the only document that I have signed. I've noticed that no other document has a date. It was only that one, and on the computer it was also only that document that was signed and a date with it. So it does not exist, to answer your question. I don't have it.
As the Commissioner pleases.
Thank you, Mr. Vani. Mr. Kwala?
Chairperson, I'm advised that we need to rearrange our seating arrangement.
Yes, you may do so whilst we are seated.
Thank you, Chairperson.
Ms. Ranto will gladly move from her seat to allow you to sit where she is seated.
Good day, Mr. Ackerman.
Good day.
Can you assist me here? Can you give me the timelines? When was the decision to charge to prosecute rather in the matter of Reverend Chikane taken? Just a month?
No, I can't give you a month. It must have been between 2003 and 2004. If you ask me, already after the court trial, I had it in mind as a case. But you asked me whether it was approved, because the TRC matter must be approved by the NDPP or acting NDPP. So I can't give you a precise date, but yes, that's my answer.
You can't say it was 2003, the first half or the second half of 2003, or the first half or second half of 2004.
Look, it was one of the first cases that I did when I was there. I'm just thinking now, the Petco 3 matter was March 2003. You know, it was getting that period. I don't know whether it was first half, second half. You know, I had quite a few cases that I decided were good cases to proceed with the prosecution.
So the final answer is that you do not know when the decision to prosecute was taken. Is that how I must understand your answer?
No, it was during 2003.
All right. You can't tell us whether it was beginning or towards the end of 2003.
He said so.
No, it was 23 years ago.
All right. But what we know,
Yes, may proceed.
sorry
Mr.
for the
Kwala.
late reaction. What we know is that the indictment was prepared in 2004. Would you accept that?
I'll accept that. If you,
And
maybe even
that-
earlier.
Come again?
It might be even earlier.
But we do know from your evidence that it was in November 2004 when the minister said penned these cases pending the issuance of the policy guideline on prosecution.
That's correct.
All right. Now, my concern is this. If the decision was taken in 2003, be it at beginning or towards the end, and then the indictment was to be served on the accused in November, what would explain that delay? At least you can take it from January 2004, since you do not know when the decision was taken. What would explain the delay between January 2004 and November 2004? Why were these individuals not charged and taken to court during that period?
You know, sitting here, I can't accurately say what the reason was, but there were some other investigations that had to be done. That I know.
It's the same matter.
Yeah, Chani matter.
All right.
Because
Yes,
I went to Madison to obtain certain documents and toxicology reports, and that's why I say I know I needed some evidence still.
So a decision was taken whilst the investigation was going on?
Yes.
Okay. Can we deal with something else quickly? And for this, I want to take you to your... Can I be advised if I'm not audible? This thing is disturbing me. Thank you. Can I take you to your statement in the Ackerman bundle? It's an affidavit, actually, the affidavit you deposed to in the High Court matter. It is
2015.
2015, yes, Mr. Ackerman. And there, I want us to deal in a moment or in a short while with what you characterize as political interference. Tell me when you found the page.
Yes, I have it.
You deal
Which
with this-
paragraph?
You deal with this in paragraph 32. That's where you start.
Yes.
You say the first act of political interference, which effectively stopped the work of the PLCU into the TRC cases, was the suspension of such cases during 2004, pending the issuing of the new prosecution guidelines. This,
Yes.
this introduced the effective moratorium I referred to above. The high watermark of your case, Mr. Ackerman, is not just that there was interference, it's that there was political interference. Do I understand you correctly?
Yes, certain matters I regard as political interference, but after reading the terms of reference, you don't need political interference. It's simply interference or putting pressure on.
Yeah.
But at the stage when I drafted this, this affidavit was 2015, was it not?
Yes, it would be.
So, I'm of the view at this stage it's irrelevant whether it was political or not.
Yes. All right, let's deal with that still. You say it is that interference that effectively stopped the work. If I read that paragraph correctly, you refer to interference and the effective stoppage of the work in the TRC matters.
So what's your question?
Let me put it again. There are two things I'm picking up from that paragraph. Is that you say there was an interference, that's number one, and that interference effectively stopped the work on the TRC cases.
Do you agree
That's
with
correct.
that statement or not?
I agree.
As I understood your evidence in chief, or at least when we sought clarities, you agreed that that was a temporal measure to allow the process of developing the policy guideline. It was not a total ban to the prosecution of the TRC cases.
Yes, it was a 2-year delay that I was hindered and obstructed to execute my mandate.
What stuns me in that, though, is that we had evidence, and it was demonstrated in court by Mr. Maga, that in 2005, he was engaged in a trial that had to do with the conflict of the past.
Which case was that?
One is case of Chani in the Eastern Cape.
I was not even aware of that case. It was not with my office.
What I'm saying is, what I understand the position to be is that you say, because the minister issued a directive, if I call it that way, that the TRC cases must be put on hold pending the issuance of the policy guideline. But in this, perhaps let's go on, the guideline was issued or became effective towards the end of 2005. Is that your understanding?
That's correct. The last part of your statement is correct.
Yes. But before, in fact, it was December 2005. Before December 2005 and within 2005, Mr. Marcus tells this commission that he was prosecuting a matter that was connected to the conflict of the past, the TRC cases. How is it then that you would say the directive by the minister, as you put it, effectively stopped the prosecution of the TRC cases?
When did this case of Mr. Maga start?
We'll open for you.
I wonder, was Mr. Maga seems to have said he was not even aware.
The point is that these are all TRC cases. If it stopped if the directive by the minister stopped the prosecution, then it would apply to all the TRC cases. And to take it further than that, Justice Hall?
No, the only point that I want to make is that unless I'm mistaken, Mr. Mahaka was not even aware of what the minister was accused of, rightly or wrongly. So he proceeded.
In ignorance?
Yeah.
No. Let's take it further than that, Justice Hall.
Yeah, maybe you can.
No, I think just the JP is not stopping you from asking the question, was merely pointing you out to the evidence of Advocate Mahaka in this regard.
Yes. But, yes, thank you, Chairperson, for that. But as I go on with this,
don't try to justify it. The chair says continue with your line of questioning.
okay.
That's
How is it then that it was not communicated, for instance, to other prosecutors that they would not continue with the TRC cases?
If you ask me, I didn't send a letter to each and every division saying they must stop all the prosecutions. What happened, as I said in some of my reports, there were some cases in the divisions, the 9 divisions, that those prosecutions and trials went along. I was not involved in them. And I think that the case that Marga is referring to is a case that started long before 2004, or I don't know even when it started. That's why I asked.
Yes, but
Bottom line is I didn't inform him.
so you can then say what minister said effectively stopped the prosecution in the TRC cases.
I was of view of it that it effectively stopped all my investigations and prosecutions.
All right. Can we deal with something else as well that you mentioned this morning? My colleague for the police asked you what was the first act, what do you regard as a first act of political interference? And you said it was when Commissioner De Beer said he would not investigate the TRC cases. You recall that?
Yes?
Do you regard that as interference or as someone who just does not want to perform their function?
Both?
How is it an interference then, if it is both?
Well, the interference is he's not assisting me with investigations, and in terms of the Police Act, he must assist me. He must investigate.
An interference in prosecution would be a crime, isn't it?
Yes, very much so.
Did you regard his conduct at the time when he said he would not investigate them as interference in the prosecution?
Well, can I just repeat that question?
What, did you at the time when he said he would not investigate the TRC cases regard that as an interference?
Yes.
What did you do about that?
Nothing. I went back to the Dwaba and found out whether he will be prepared to investigate. And I went to Mr. Muka and I went to Dr. Ramahiti, informing them that both the investigating agencies refused to assist me in these important, the investigation of these important cases.
To the extent that Commissioner De Beer was interfering in the prosecution, as I understand you to be asserting, you did not do anything about that.
What do you expect me to do so that I can reply to it?
We've just agreed that that was a criminal offense for him to interfere.
I didn't lay a criminal charge.
Why not?
Under the circumstances, you have to discuss this with the... I didn't. You know, I don't have to explain why I didn't. There are lots of crimes committed by ministers that I didn't go and lay a charge. For instance, the Minister of Justice informing, stopping a prosecution, phoning Dr. Ramiti. I didn't go and lay a charge at Silverton Police Station.
Yes, I was going to come to that one too. But you say you were aware that a person at the level of a commissioner was committing a crime and you decided to do nothing about it.
I did say that. I didn't lay a charge. That's what I'm saying.
Is that not because at the time you did not regard that as an interference?
No, it interfered with my mandate, the execution of my mandate.
Let's accept that for a moment, but my question is it not because you did not take an action, granted, but is that not because at the time you did not regard his conduct as an interference?
I regard it as an interference.
Okay. And as a prosecutor who would have taken an oath to prosecute without fear or favor, you ought to have taken some action against Mr. De Beer.
Well, it's a statement you make.
Do you agree or you don't agree?
I did not charge.
I'm asking a different question now. Do you agree with that statement or not?
I don't agree with it.
You don't agree with that. That would be your answer even with regard to the minister when you say she interfered when she told the NPA to stop the prosecution.
We should lay that charge.
The prosecutor who knows that a crime has been committed so that it is
Well, that's Dr. Ramahiti.
Did you discuss it with him?
Yes.
That he should lay a charge?
No.
You wouldn't, because you had also allowed a situation where the commissioner had said he would not investigate and you did not lay a charge.
Listen, I've been disciplinary action taken against me for being, what's the word?
Insubordinate?
Supporting a senior. You know, I had enough charges against me. If a charge was to be laid, it was Ramahiti. I had a long argument with him stating that the minister cannot give that order. And he told me that I must stop the prosecution and stop all prosecutions and investigations. This echoing is putting me off.
You know, I'm asking these questions to be frank with you, Mr. Ackman. Because I'm trying to establish if, are we not just dealing with a case of some individuals who chose not to do their work and now they jump into the work of the interference?
Were you referring to Commissioner De Beer?
Including yourself?
Are you stating that I was not interested in prosecuting TRC cases?
I've not yet said that. I'm saying I just want to be frank with you so that you understand my theory. I'm just trying to establish if are we not necessarily dealing with a case whereby individuals simply sat back and did not do their work? You don't have to answer that question.
I will.
You can if you want.
Or you can go and have a look at all the persons working at the PCLU. Some of them work 18 hours days, and I'm referring to Sean Abrams. We were doing our best to prosecute TRC cases. Go through the documents and you will see it.
Okay, I'm happy to hear that. Can we deal with something else quickly again? We listened to the evidence of Advocate Ledwaba yesterday. I will summarize what he says. He says between May 2003 and November 2003, you had approached him to source assistance from his directorate, the DSO, if they could give you investigators to assist you in the TRC cases. That's just the summary. He says in May he told you that he cannot, you would rather approach the NDPP. You came back in July with the same request and he said so. He repeated himself. And only in November did you approach the NDPP. Now, there is a period that lapsed between May and November when you did not have investigators, notwithstanding the advice that you had been given. That, to me, appears to be someone who is just sitting and not taking action in the work that they are supposed to do.
I deny it.
You deny that. All right. I will take you now to your transcript of 4 March 2026. That's your evidence. I'm taking you. Do you have it, Mr. Akama?
Beg your pardon?
Do you have the transcript of 4 March 2026 when you were giving evidence?
Yes, I've given a bundle with my evidence.
All right. I want to take you to page 10 of the transcript.
Got it?
And I want us to start at line 5.
Yes. I'm there.
Just give me a moment, Mr. Ackerman. I think I'm giving you a wrong page.
I think so.
But it is a good paragraph there.
Wait a minute. When he was talking to Wagner. Yeah, page 10. Is that 5? Is that 4 of March? Page 10. Mr. Ackman, I'm going to. Okay, I've found it. I'm going to summarize what is your discussion. I don't think that my page numbering is correct. I made an error when I was taking a note, and I won't find it now. But the scene is that you were discussing with Mr. Wagner. Mr. Wagner told you that there are a number of meetings between the ANC leaders and the General of Police and Security Forces. And they are all in search of a political, in a search of a political intervention to prevent prosecution of security forces. Do you recall that part of your evidence?
Yes, that's what he told me. It was not a discussion.
Yeah. Why did I want? Oh yes, it is, commissioners. It is indeed page 10. The line is indeed line 5. I think I just got my spectacles not working. I understand you were not part of these meetings. I accept that.
Which meetings?
Let's read it then. You are talking to Mr. Wagner. Mr. Wagner tells you that there were meetings that were held between the ANC and the police generals. You recall that?
Yes.
I'm saying, I take it, I accept that you were not part of these meetings. But do you know if there were minutes that were taken?
Are you asking me a question?
Yes.
I was not there. I don't know what he was talking about.
Was there a directive that you know of that came out of that meeting instructing you, the prosecutor and the other prosecutors, not to prosecute these cases?
You know, talking about meetings that took place in the 90s, I think.
Was there a direction given from that meeting to the prosecutors, including yourself, that there should be no prosecution?
Not to me.
To anybody else?
I wouldn't know.
All right. Again, did you regard what Mr. Wagner was telling you about these meetings, an attempt to find a political solution not to prosecute the TRC cases? Did you regard that too as a as an interference in the work of the prosecution? At the time when you were talking
He
to him?
didn't interfere with my work. He told me it's going to be futile, but I said, yes. I just started prosecuting, investigating. I took no notice of it. It didn't affect me at all.
You were right in doing that. and I applaud you for that. But my question is, did you regard what he told you as an interference in the prosecution work?
You know, if I listened to him, it would have been interference. But the fact it was like water off my back.
Were you not concerned that it was a criminal offense that was being committed? Sorry.
No. But even if it was, I wouldn't have come to Silverton police station.
You wouldn't have reported it to police station so that it is investigated?
No. But what I did tell him at one stage is when he threatened me every time with this prosecution against the ANC 37, if he once again threatened me, I will go to Silverton police station and report him. That's the only time I said to him, he must now stop with his threats.
But at this level, I'm interested in what he was telling you about the ANC and the generals who were interfering in a way with the prosecution by preventing the prosecutions. Would you not have thought that this is a matter that should be investigated and be dealt with?
Well, what must be investigated?
The fact that there are people who are intent on preventing the prosecution.
Intent
I
on
was
preventing
informed that
Mr.
the ANC leaders were also...
Sorry, Advocate Ackerman, before you respond, Mr. Gwala, intent on preventing the prosecution or the discussion.
Who were involved on the discussions to prevent the prosecution?
No, there were two parties. Was the ANC leaders on the one side and the generals on the other side. What do you expect me to do? I didn't have any evidence even to that effect. It's just what Wagner told me.
No. I'm concerned about what your reaction. Did you not see it fit that it was something that had to be reported to the law enforcement so that it could be investigated?
No.
All right. All the same, Mr. Wagner did not say that the meetings had resolved that the NPA would be influenced or pressured to stop the prosecution. Did he?
What's your question?
Your discussion, what he told you was not that the meetings had resolved that the NPA would be influenced or pressured to not prosecute the TRC cases.
He didn't use those words.
Hence, you were at liberty to continue with your work.
I continued with my work. I took off my back.
Can you recall your evidence about the task team, the interdepartmental task team?
Yes,
And if I understand your affidavit in the 2015 matter, you regard what happened there as part of interference with the prosecution.
That's correct.
Perhaps let's look at what you say. in your affidavit, I referred you to that affidavit. It's Ackerman bundle, and you deal with this in page 15 of that bundle, and from paragraph 33. You say once the guideline had page 33.
Yes, I've got it.
Paragraph 33, my apologies.
Got it?
Yes. You say once the guidelines had been issued and the multi-departmental working committee was established in 2006, it became clear that the SAPS and NIA representatives believed they were part of the prosecutorial decision-making process.
Yes?
And then in paragraph 34, you say the NDPP objected to this approach on the basis that it would constitute an unwarranted interference in the work of the NPA. So when they came to the meetings, or one of the meetings, they had the attitude that they could participate in the process, in the decision-making process. But this
I don't think the NDPP was referring to the task team.
Yes.
He was referring to that letter that SAPS wrote, that Jacobs wrote, if you look at paragraph 33.1.
Yes.
Have a look at it.
Yes, 33.1 and 33.2.
Yeah.
But those would have been the culminations of what happened in the ITT meetings.
No, as a result of that, the directors generals wanted to know what was going on. They were the puppet masters, as I said. The task team was just puppets.
Yes. And at the task team level, they believed that they could be they were part of the prosecution decisions.
That's correct. In fact, yeah.
And there was a letter that was received by the PCLU on 6 December from Major General P.C. Jacobs,
Yes.
which indicated that before the prosecutorial decision was made in respect of the TRC cases, the task team would have been the multi-departmental task team, as I understand what you are saying. They must submit a final recommendation to a committee of directors general in respect of each case, which in turn must advise the NDPP in respect of who to prosecute and who not to prosecute. So I understand this letter was a culmination of what would have happened at the task team meetings.
What's the question?
Is my understanding correct?
If you want my view on the matter, it was all unconstitutional. It was interference. They had no decision-making authority.
I accept that 100%. They had not, but when they were in the meeting, they thought they had that authority.
That's correct.
Yes.
Yes.
But then the NDPP objected to this and stated that no, the decision to prosecute is mine and mine only.
Correct.
Did the task team continue holding the view that they were part of the decision making after the NDPP would have objected to that?
give me, the last meeting was in January, is it 2007 or is it not 2006? And in 2007, there were 5 meetings. I don't know when he objected.
I didn't hear the last part.
I said, when did he object? Wasn't that 15th of July? No, that was February 2007, if I'm not mistaken, 15th February.
Yeah, what I'm interested to know is, after that, whether it's July 2007, after he had objected, did that view by the members of the task team continue?
I don't think they existed at that stage. The last meeting was January.
Okay, can we settle it this way then? The NDPP asserted his position that no, the decision to prosecute is mine, and did not take instructions from or advice from the task team or even the Director General's forum.
Okay. Well, what's the question?
Can we accept that, notwithstanding the view that the task team held, that they had a role to play in the prosecution, the NDPP stood his ground and said, no, the decision to prosecute is mine and mine only, and that was the end of it?
That's 2 questions. I don't know if it was the end of it, but he said I am the person who is going to prosecute.
Did they continue to make recommendations on who to prosecute and not to prosecute after he had said so?
No, because it didn't exist.
Oh.
There were no meetings.
But all the same, neither the task team, you cannot tell the commission today that either the task team or the DG's forum took a decision that there would be no prosecution of the TRC cases. Can you?
Well, they did not want the prosecution of Chani, the perpetrators in the Chani matter.
Can you repeat that?
They were against a prosecution of the perpetrators in the Chani matter, still.
Okay, but the question is, did they instruct members or a member of the NPA not to prosecute Reverend in the Reverend Chikane matter?
Who can they talk to?
So
They must get rid of the prosecutor.
So must I take...
This echo is bothering me.
I'm sorry about that. I will be slow. Must I take it that you are telling us that neither the task team nor the DG's forum took a decision to instruct the NPA not to prosecute in the matter of Reverend Chikane? They were just against it, but they did not give an instruction that there should be no prosecution.
Well, what I've heard from Mr. Simelane, at meetings where the commissars and commanders stated that he should immediately stop the prosecution. And who's taking the decision? You or Ackerman? That's what, I'm just speaking what happened at these interministerial meetings.
was that not a question seeking explanation as to who is taking the decision, which is different from my question, because my question is, are you telling us that they did take a decision to instruct the NPA not to prosecute?
They didn't tell me.
All right. Was there a stage, other than what you tell us about the suspension of the prosecution, when you were still waiting for the guidelines, was there a stage where you were told not to prosecute on the TRC cases?
Yes.
By who?
Dr. Ramaiti told me not to prosecute or investigate any TRC prosecutions till the approval of new guidelines.
Is that the only instance where you were told not to prosecute? The
That
TRC
I can
cases?
think of. I don't know who else can inform me.
No. I don't know either. What I want to know is, other than what you are telling us about Dr. Ramaite, is there another instance where you were told not to prosecute the TRC cases?
Yes or no?
Not that I can. No.
Because I understand that even in Dr. Ramaite, he was saying, wait for the promulgation of the policy. Not that there should be no
That's good.
prosecution at all.
That's correct.
So we now know that other than you being instructed to wait for the promulgation of the policy guidelines, you were never instructed not to prosecute the TRC cases.
Yeah, I'm thinking not at this stage, but if you can refresh my memory and ask me, this person told you to stop, I can comment on that.
I was not there, Mr. Ackerman. I can't refresh my memory. I want to know from you.
But
No, okay, no.
But what during the moratorium, until the witness is told by those who communicated to him that there is this moratorium. So, and he was informed by his senior, Dr. Ramaite. Until the moratorium is lifted, what could he do? What could a witness do?
I don't understand. I don't understand that question.
No, you're asking him a question that, apart from the interregnum, the moratorium, was there any other instance? Now I'm saying, you know, or let me ask you, Mr. Ackerman, was the moratorium lifted, and if it was lifted, when was it lifted?
It must be the end of December 2005.
Yes, you may proceed. You may proceed on your own line, not on my line. Any line that you want to take.
No, thank you, Justice Kwame. There are two instances. There is an instance where you were told that there is now a moratorium and you would not prosecute. Let's accept that that is what your evidence say. But what I wanted to know is that the only instance where you were told not to prosecute. That's all I wanted to.
As far as I can recall, yes, you.
All right. Can I just consult my junior?
Yes, you may. Yes, we are adjourning.
Why did you recruit Mr. Maga in 2005 when there was still a moratorium for him to come and work on the TRC cases? If
We
there
had
was a-
too much work.
Come again?
We had too much work. You know, you're just talking about TRC matters. I've given evidence that TRC matters took about 20 to 25% of my work. This other 75% of my work to carry on.
So he was not going to work on the TRC cases only. That's what you said.
No,
Okay.
Mr. Kwala, I just want to draw attention to the time.
I'm almost done,
Yes.
Jefferson. I'm almost done, really. Can we deal with your removal from the TRC cases? And we'll deal with this very quickly. Sorry, just before that, let's finish on the ITT. It's just one question. As I understand it, the ITT they thought they could make recommendations to the NDPP as to who to prosecute and not to prosecute. And those would be the recommendations that the NDPP or the prosecutor would consider in making a decision. Those would not be the instructions on him not to prosecute.
you know, give me a simple question. I don't know what you're asking me.
Recommendations of the ITT would not be binding on the DPP.
No,
when
it would not.
It would not. All right. Can we
But I
talk
think they were of the view that it must be binding. If you look through all the minutes, you will see Josiah once said at the meeting that decisions that I've made not to prosecute, he will not accept that, and they have to decide, make a decision on that.
neither you nor the DPP nor any of the prosecutors succumbed to that thinking of the ITT members?
If,
You know,
if you say Josiah's, you refer to Josiah's lekalakal.
I beg your pardon?
You say you refer to Josiah's. Now I say, by referring to Josiah's, are you referring to Josiah's lekalakal?
Correct.
Yes. Okay.
The question I was asking was, neither yourself nor any of the prosecutors, including the DPP at the time, succumbed to the thinking of the ITT that they could participate in the decision-making of the prosecution decision.
I can only speak for myself. I wanted to get investigators and I wanted to prosecute TRC matters. I had to play along whatever they say, but I was of the view that they had no decision-making authority.
just on that, you could not prosecute because you did not have investigators.
That's correct.
All right. Now, you were removed from the TRC cases. I'm taking you to the transcript of 5 March 2026 at page 33. Can you open that for me? March, 5 March 33. Whilst we are paging, after you were relieved of the TRC cases, you remained as the head in the PCLU. Is that correct?
That's correct.
And your subordinates would continue to report to you and give you the reports as the head.
Hopefully, yes, they did. I know I've seen a few reports. We had discussions, Argan, and McAdam.
And those reports would include reports on TRC cases.
That's correct.
So you were not completely removed from the TRC cases. You still remained in your position and you were fed information with regard to the TRC cases.
I was managing it in managing them. I did no operational work relating to TRC matters. You understand what I'm saying? I did not investigate or prosecute.
Yes. And you say, you said in your evidence, after you were removed, it became the responsibility of Dr. Ramaite and Advocate Maga to work on the TRC
No, I did
cases.
not say that.
Let's find it. At page 34, no, I don't know. At page 34 of the transcript that I referred you to,
Yes.
transcript of 5 March 2026, at line 8, Advocate Ackerman, after suspension of Mr. Piccoli, this is why my diaries are very important, because it will be reflected in my diaries when he relieved me. And it says, I have decided that all future post-TRC investigation and prosecutions be managed by Dr. Ramaite and Maga and the TRC task team.
No, I did not say that.
Is this not your evidence?
It appears to me there, but what happened is that Mr. Mshe wrote that he appointed Maga and Ramaiti to do the work. So we can go and listen but I mean, that's not the position. I didn't appoint them. In fact, the first time I heard about this was when I read the letter of Mr. Mshe to Reverend Chani. That's the first time, because I never knew that the three of them were doing the TRC matters. I recommended that Chris McAdam must be in charge of the TRC matters.
But these people were reporting to you. You didn't know that they were working on TRC cases.
I beg your pardon?
But they
I
were
can't hear
reporting.
you.
They were reporting to you when they.
What is
They're
the
reporting
question,
to me.
Mr.
Now
Kwala?
that
Sorry, Advocate Ackerman.
How is-
What is the pointed question now, Mr. Kwala?
How is it that he does not know that these people were working on the TRC cases?
I think ask the question first. Was he aware that Advocate Mahaka and Mr. Ramaite were working on TRC cases.
Can you answer that? Thank you, Commissioner. Thank you.
Yeah, I didn't know that.
All
And
right.
they didn't inform me.
All right. But in that part of the transcript, this is the part I'm interested in. The last sentence in the portion that I was reading, you say, well, at least now we know who did not work on the TRC matters. Were you suggesting?
Now it makes sense to me. If you read at paragraph 10, it says, I say, and it says. Now I'm referring to the letter of Nshe to Reverend Shakani. He says, I have decided that all future post-TRC investigations and prosecutions be managed by Dr. Ramaiti, Advocate Maga, and the TRC task team. I didn't say that. If you go to the letter of Nshe, you will see that he is the one who stated that. You know, it's always difficult reading a transcript when I can understand why you say you thought I said that.
Yeah.
Mr. Kwala, because I know you are making an honest mistake, I would like to draw attention to the fact that the discussion relates to the letter that was written by Advocate Mshe,
Yes.
as you will see when you look at page 33.
Yes.
Yes,
Okay. Thank you, Chairperson.
yes.
I'm corrected. But the last sentence there in that line, Dr. Advocate Ackerman says, well, can you see it? Well, at least,
Yeah.
well, at least now we know who did not work on the TRC matters. Is that?
It's a very,
Wait, Mr. Ackerman,
Is that your statement, or is that what was written in the letter that you were referring to?
no, that was a very unfortunate statement by me.
So that is your statement.
That's my statement. Because it came to us as a surprise to me that Maga and the task team and Ramaiti is now in charge. The task team did not even exist at that time. Maga never came to me and said to me, I'm now in charge of TRC matters, nor did Ramaiti inform me.
Yeah. So you were wrong to say we now know who did not work on the TRC matters. In fact, let me put
I
it this
don't-
way. You are prepared to retract that statement.
Yeah.
Mr. Kwala, I must draw attention to your watch.
I just want to hear what my junior says. She might just say I must stop.
Yes. Ms. Ntloko?
One final question, and this is the real final question, Mr. Ackerman. When the minister made the call to the acting NDPP saying suspend the prosecution pending the development of the prosecution policy. You do know that minister does play a role in the promulgation of the policies, prosecution policies, in terms of the NPA Act.
No, she has no operational duties.
I'm talking about developing in the promulgation of the policy.
No. What happened here, these policies were created and formulated by the directors general and not by the task team.
The Constitution and the NPA Act gives the minister a role in the formulation of the policy. That is the law, it's not necessarily the evidence. I will leave it there, Mr.
No, you know what? That the Act says section 1795. Now it's a constitution that states that the NPA must formulate the policies and the minister must concur with it. What happened here was the policies were formulated by the directors general.
But Mr. Ackerman, that's not the point. The point is the minister legally has a part to play in the formulation of the policy. You can't gainsay that because it's the law. The minister's powers are not excluded in that regard.
She must, I do not agree, Commissioner. With concurrence means in agreement. We formulate, the NPA formulate the guidelines and she must concur. Not she formulate the guidelines and the NPA must concur.
Thank you, Chairperson.
Thank you, Mr. Kwala. Mr. Vani, I think we have approached the time when we agreed would allow Advocate Ackerman an opportunity to be excused for today's proceedings.
That's correct, Chairperson.
Yes, and I don't think you will be 5 minutes with your re-examination of your witness.
I might be a bit longer.
Yes. In that case, we'll adjourn these proceedings until 9 o'clock tomorrow morning,
As the
when you
Commission
will
pleases.
commence with your re-examination.
Thank you, Chairperson.